Welcome everyone. Today I am continuing reading chapter 2 of the BNSS. Chapter 2, 6th point. Besides the high courts and courts constituted under any law, other than this Sanhita, there shall be in every state the following classes of criminal courts, namely courts of session, judicial magistrates of the first class, judicial magistrates of the second class, and executive magistrates. Every state shall be a sessions division or shall consist of sessions divisions, and every session division shall, for the purpose of the Sanhita, be a district or consist of districts. The state government may, after consultation with the High Court, alter the limits or the number of such divisions and districts. The state government may, after consultation with the High Court, divide any district into subdivisions and may alter the limits or the number of such subdivisions. The sessions divisions, districts, and subdivisions existing in a state at the commencement of this Sanhita shall be deemed to have been formed under this section. The state government shall establish a court of session for every sessions division. Every court of session shall be presided over by a judge to be appointed by the High Court. The High Court may also appoint additional sessions judges to exercise jurisdiction in a court of session. The sessions judge, one of sessions divisions, may be appointed by the High Court to be also an additional session judge of another division. And in such case, he may sit for the disposal of cases at such place or places in other divisions as the High Court may direct. Again, the sessions judge of one sessions division may be appointed by the High Court to be also an additional session judge of another division, and in such case, he may sit for the disposal of cases at such place or places in the other divisions as the High Court may direct. Where the office of the sessions judge is vacant, the High Court may make arrangements for the disposal of any urgent application which is or may be made or pending before such courts of session by an additional sessions judge, or if there be no additional sessions judge, by a chief judicial magistrate in the sessions division. And every such judge or magistrate shall have jurisdiction to deal with any such application. 6th point. The court of session shall ordinarily hold its sitting at such place or places as the High Court may, by notification specifying. But if in any particular case the court of session is of opinion that it will tend to the general convenience of the parties and witness to hold its sittings at any place other place in the sessions division, it may, with the consent of the prosecution and the accused, sit at that place for the disposal of the case or the examination of any witness or witnesses therein. The sessions judge may, from time to time, make orders consistent with this Sanhita as to the distribution of business among such additional sessions judges. 8th point. The sessions judge may also make provision for the disposal of any urgent application in the event of his absence or inability to act by an additional sessions judge, or if there be no additional sessions judge, by the chief judicial magistrate. And such judge or magistrate shall be deemed to have jurisdiction to deal with any such application. Explanation. For the purpose of this Sanhita, appointment does not include the first appointment, posting, or promotion of a person by the government to any service, a post in connection with the affairs of the union or of a state, where under any law such appointment, posting, or promotion is required to be made by the government. 9th point of subclass 1. In every district there shall be established as many courts of judicial magistrates of the first class and of the second class, and at such places as the state government may, after consultation with the High Court, by notification specify, provided that the state government may, after consultation with the High Court, establish for any local area one or more special courts of judicial magistrates of the first class or of the second class to try any particular case or particular class of cases. And where any such special court is established, no other court of magistrate in the local area shall have jurisdiction to try any case or class of cases for the trial of which such special court of the judicial magistrate has been established. Second subsection. The presiding officers of such courts shall be appointed by the High Court. Third subsection. The High Court may, whenever it appears to it to be expedient or necessary, confer the powers of a judicial magistrate of the first class or of the second class on any member of the judicial service of the state, functioning as a judge in a civil court. 10th point of subclass 1. In every district, the High Court shall appoint a judicial magistrate of the first class to be the chief judicial magistrate. The High Court may appoint any judicial magistrate of the first class to be an additional chief judicial magistrate, and such magistrate shall have all or any of the powers of a chief judicial magistrate under the Sanhita or under any other law for the time being in force as the High Court may direct. The High Court may designate any judicial magistrate of the first class in any subdivision as the subdivisional judicial magistrate and relieve him of the responsibilities specified in this section as occasion requires. Subject to general control of the chief judicial magistrate, every subdivisional judicial magistrate shall also have exercise such powers of supervision and control over the work of judicial magistrates other than additional chief judicial magistrates in the subdivision as the High Court may, by general or special order, specify in this behalf. 11th point of subsection 1. The High Court may, if requested by the central or state government to do so, confer upon any person who holds or has held any post under the government all or any of the powers conferred or conferable by or under the Sanhita on a judicial magistrate of the first class or of the second class in respect to particular cases or to particular classes of cases in any local area, provided that no such power shall be conferred on a person unless he possesses such qualification or experience in relation to legal affairs as the High Court may by rule specify. Provided that no such power shall be conferred on a person. Subsection 2, 11 of 2. Such magistrates shall be called special judicial magistrates and shall be appointed for such term not exceeding 1 year at a time as the High Court may by general or special order direct. 12th section, subsection 1. 12th point, subsection 1. Subject to the control of the High Court, the chief judicial magistrate may, from time to time, define the local limits of the areas within the magistrates appointed under section 9 or under section 11 may exercise all or any of the powers with which they may respectively be invested under this Sanhita, provided that the court of special judicial magistrate may hold its sitting at any place within the local area for which it is established. Subsection 2 of point 12. Except as otherwise provided by such definition, the jurisdiction and powers of every such magistrate shall extend through the district. Subsection 3. Where the local jurisdiction of a magistrate appointed under section 9 or section 11 extends to an area beyond the district in which ordinarily holds court. Any reference in this Sanhita to the Court of Session or Chief Judicial Magistrate shall, in relation to such magistrate throughout the area within his local jurisdiction, be construed, unless the context otherwise requires, as a reference to the court of session or chief judicial magistrate, as the case may be, exercising jurisdiction in relation to the said district. That in the section of subsection 1, subordination of judicial magistrates is a heading left side. Every chief judicial magistrate shall be subordinate to the sessions judge, and every other judicial magistrate shall, subject to the general control of the sessions judge, be subordinate to the chief judicial magistrate. Subsection 2 of 13 section. The chief judicial magistrate may, from time to time, make rules or give special orders consistent with the Sanhita as to the distribution of business among the judicial magistrates subordinated to him. 14th section, subsection 1. Executive magistrates. In every district, the state government may appoint as many persons as it thinks fit to be executive magistrates and shall appoint one of them to be the district magistrate. The state government may appoint any executive magistrate to be an additional district magistrate, and such magistrate shall have such powers of a district magistrate under the Sanhita or under any law for the time being in force as may be directed by the state government. Subsection 3 of 14 section. Whenever, in consequences of the office of a district magistrate becoming vacant, any officer succeeds temporarily to the executive administration of the district, such officer shall, pending the orders of the state government, exercise all powers and perform all duties respectively conferred and imposed by the Sanhita on the district magistrate. Subsection 4 of the section 14. The state government may place an executive magistrate in charge of a subdivision and may relieve him of charge as occasion requires. And the magistrate so placed in charge of subdivision shall be called the subdivisional magistrate. Subsection 5 of the section 14. In chapter 2, the state government may, by general or special order and subject to control and directions as it may deem fit to be imposed, delegate its powers under subsection 4 to the district magistrate. Subsection 6. Nothing in this section shall preclude the state government from conferring, under any law for the time being in force, on a commissioner of police all or any of the powers of an executive magistrate. Again, nothing in this section shall preclude the state government from conferring under any law for the time being in force on a commissioner of police all or any of the powers of an executive magistrate. Special executive magistrates. 15th section. The state government may appoint for such term as it may think fit executive magistrates or any police officer not below the rank of superintendent of police or equivalent to be known as special executive magistrates for particular areas or for the performance of particular functions, and confer on such special executive magistrates such of the powers as are conferable under the Sanhita on executive magistrates as it may deem fit. 16th section of subsection 1. Local jurisdiction of executive magistrates. Subject to the control of the state government, the district magistrate may, from time to time, define the local limits of areas within which the executive magistrates may exercise all or any of the powers with which they may be invested under the Sanhita. Subsection 2 of 16th section under chapter 2. Except as otherwise provided by such definition, the jurisdiction and powers of every such magistrate shall extend throughout the district. Subsection 17. Subordination of executive magistrates. Section 17 of subsection 1. All executive magistrates shall be subordinate to the district magistrate, and every executive magistrate other than the subdivisional magistrate exercising powers in a subdivision shall also be subordinate to the subdivisional magistrate, subject to the general control of the district magistrate. Subsection 2. The district magistrate may, from time to time, make rules or give special orders consistent with the Sanhita as to the distribution or allocation of business among the executive magistrates subordinated to him. Section 18. Public prosecutors. Subsection 1 of Section 18. For every High Court, the central government or the state government shall, after consultation with the High Court, appoint a public prosecutor and may also appoint one or more additional public prosecutors for conducting in such court any prosecution, appeal, or other proceeding on behalf of the central government or the state government, as the case may be. Provided that National Capital Territory of Delhi, the central government shall, after consultation with the High Court of Delhi, appoint the public prosecutor or additional public prosecutors for purposes of this subsection. Subsection 2. The central government may appoint one or more public prosecutors for the purpose of conducting any case in any district or local area. Subsection 3. For every district, the state government shall appoint a public prosecutor and may also appoint one or more additional public prosecutors for the district. Provided that the public prosecutor or additional public prosecutor appointed for one district may be appointed also to be a public prosecutor or an additional public prosecutor, as the case may be, for another district. Subsection 4. The district magistrate shall, in consultation with the sessions judge, prepare a panel of names of persons who are, in his opinion, fit to be appointed as public prosecutors or additional public prosecutors for the district. Subsection 5. No person shall be appointed by the state government as the public prosecutor or additional public prosecutor for the district unless his name appears in the panel of names prepared by the district magistrate under subsection 4. Subsection 6. Notwithstanding anything in subsection 5, wherein a state there exists a regular cadre of prosecuting officers, the state government shall appoint a public prosecutor or an additional public prosecutor only from among the persons constituting such cadre. Provided that where, in opinion of the state government, no suitable person is available in such cadre for such appointment, that government may appoint a person as public prosecutor or additional public prosecutor, as the case may be, from the panel of names prepared by the district magistrate under subsection 4. Explanation. For the purpose of this subsection A, regular cadre of prosecuting officers. Regular cadre of prosecuting officers means a cadre of prosecuting officers which includes therein the post of public prosecutor by whatever name called and which provides for promotion of assistant public prosecutors by whatever name called to that post. Subsection B. Subsection B. Prosecuting officer. Prosecuting officer means a person by whatever name called appointed to perform the functions of a public prosecutor, special public prosecutor, additional public prosecutor, or assistant public prosecutor under this Sanhita. Subsection 7. A person shall be eligible to be appointed as a public prosecutor or an additional public prosecutor under subsection 1 or subsection 2 or subsection 3 or subsection 6 only if he has been in practice as an advocate for not less than 7 years. Subsection 8. The central government or the state government may appoint for the purposes of any case or class of cases, a person who has been in practice as an advocate for not less than 10 years as a special public prosecutor, provided that the court may permit the victim to engage an advocate of his choice to assist the prosecution under this subsection. Subsection 9. For the purposes of subsection 7 and subsection 8, the period during which a person has been in practice as an advocate or has rendered, whether before or after the commencement of the Sanhita, service as a public prosecutor or an additional public prosecutor or assistant public prosecutor or other prosecuting officer, by whatever name called, shall be deemed to be the period during which such person has been in practice as an advocate. Section 19 of subsection 1, assistant public prosecutors. The state government shall appoint in every district one or more assistant public prosecutors for conducting prosecutions in the courts of magistrates. Subsection 2. The central government may appoint one or more assistant public prosecutors for the purpose of conducting any case or class of cases in the courts of magistrates. Subsection 3. Without prejudice to provisions contained in subsections 1 and 2, where no assistant public prosecutor is available for the purposes of any particular case, the district magistrate may appoint any person to be assistant public prosecutor in charge of that case after giving notice of 14 days to the state government, provided that no police officer shall be eligible to be appointed as an assistant public prosecutor if he, subsection A, has taken any part in the investigation into the offence with respect to which the accused is being prosecuted, or subsection B, is below the rank of inspector. Next, Directorate of Prosecution. Subsection 20, subsection 1, subsection of A. A directorate of prosecution in the state consisting of a director of prosecution and as many deputy directors of a prosecutions as it thinks fit. And subsection B, a district directorate of a prosecution in every district consisting of as many deputy directors and assistant directors of prosecution as it thinks fit. Section 2. A person shall be eligible to be appointed, subsection A, as a director of prosecution or a deputy director of prosecution if he has been in practice as an advocate for not less than 15 years or is or has been a sessions judge. Subsection B. Under a person shall be eligible to be appointed, subsection B, as an assistant director of a prosecution if he has been in practice as an advocate for not less than 7 years or has been a magistrate of the first class. Third section. Section 3. The Directorate of Prosecution shall be headed by the Director of Prosecution who shall function under the administrative control of the Home Department in the state. Section 4. Every Deputy Director of Prosecution or Assistant Director of Prosecution shall be subordinate to the Director of Prosecution and every Assistant Director of Prosecution shall be subordinate to the Deputy Director of Prosecution. Section 5. Every Public Prosecutor, Additional Public Prosecutor, Special Public Prosecutor appointed by the state government under subsection 1 or subsection 8 of section 18 to conduct cases in High Court shall be subordinate to the Director of Prosecution. Section 6. Every public prosecutor, additional public prosecutor and special public prosecutor appointed by the state government under subsection 3 or subsection 8 of Section 18 to conduct cases in district courts, and every assistant public prosecutor appointed under subsection 1 of Section 19 shall be subordinate to the Deputy Director of Prosecution or the Assistant Director of Prosecution. Section 7. The powers and functions of the Director of Prosecution shall be to monitor cases in which offences are punishable for 10 years or more, or with life imprisonment, or with death, to expedite the proceedings and to give opinion on filings of appeals. Section 8. The powers and functions of the Deputy Director of Prosecution shall be to examine and scrutinize police report and monitor cases in which offences are punishable for 7 years or more, but less than 10 years, for ensuring their expeditious disposal. Section 9. The functions of the Assistant Director of Prosecution shall be to monitor cases in which offences are punishable for less than 7 years. Section 10. Notwithstanding anything contained in subsections 7, 8, 9, the Director, Deputy Director, or Assistant Director of Prosecution shall have the power to deal with and be responsible for all proceedings under this Sanhita. Section 11. The other powers and functions of the Director of Prosecution, Deputy Directors of Prosecution, and Assistant Directors of Prosecution, and the areas for which each of the Deputy Directors of Prosecution or Assistant Directors of Prosecution have been appointed shall be such as the state government may, by notification, specify. Section 12. The provisions of this section shall not apply to the Advocate General for the state while performing the functions of a public prosecutor. Section 12. Last section in the chapter 2. The provisions of this section shall not apply to the Advocate General for the state while performing the functions of a public prosecutor. The provisions of this section shall not apply to the Advocate General for the state while performing the functions of a public prosecutor. Next, chapter 3. Power of courts. Courts by which offences are triable. Subject to the other provisions of the Sanhita, we will start chapter 3 in next episode. Thank you for listening. Please give your feedback in the comments below. Thanks for your time.